I want to start by welcoming everyone and thank you for attending. My name is Kristen Peacole, and I am the Assistant Director at ALA's Office for Intellectual Freedom, or OIF. It's my pleasure to introduce today's webinar, Student Rights, Protests, and Free Speech. Throughout the program, we encourage you to use the chat box at the lower right corner of your screen to share comments and raise questions. The chat is being monitored, and your questions will be saved and brought forward during the question and answer session at the end. But you're also welcome to save your questions until then if you'd like. All the links throughout the slides are live and will open in a new window without knocking you out of the webinar. I also want to let attendees know that today's session is being recorded and that an archived version of the webinar will be emailed today or tomorrow. If you have any questions or concerns about this, please get in touch with me after the webinar. I am now delighted to introduce Emilio de Torre.
Thank you, Kristen.
Emilio,
thank you.
hey.
Can everybody hear me okay? Great. Thank you very much for inviting me to do this workshop on student rights, protests, and free speech. I'm thrilled to do this. Normally, I do workshops like this in person, so bear with me. I'm less familiar with webinars, but no less excited. And ironically, this photo here is of me at a student protest in Shorewood High School. So I'll click through these. Everything we're going to be talking about concerning rights of both staff in schools, whether it's a high school or a college, or students in schools, is based on the Constitution, certainly the Bill of Rights, and your various state constitutions, as well as rules and policies that your schools have laid out. Just to take a step backwards for a second, I'm the Youth and Program Director for the ACLU of Wisconsin, and a former public school teacher from New York City, among other things. What the ACLU does is basically threefold. We educate, advocate, and litigate. You can see also we tend to make giant puppets, and this was a 14.5-foot tall articulated puppet that we used in an immigration rights rally. Right now, this workshop is important because essentially campus racial climate, among other things, and certainly the national and state elections have created a lot of turmoil, a lot of fear, and many questions on campuses. I've spent the last several weeks post-election meeting with adults, college faculty, college students, and high school students addressing fears about their rights on campus, Muslim registry, immigration rights, surveillance, and we're going to touch upon some of that a bit. Most importantly, the First Amendment plays into what we'll be talking about. And here you can see I have the cast of Hamilton, most importantly because James Madison, who authored the majority of the amendments, is seen dancing there on stage with Lin-Manuel Miranda. And although I tend not to read slides literally, this is important for a quote, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So to illustrate it with a comic, which I prefer as an avid comic collector, you can see this comic here from XKCD, which is a great web comic. When I break this down, I refer to it as RAPS, religion, assembly, press, and speech. And protected speech is really shielding individuals from government trying to squash their free speech rights, not so much individuals trying to squash free speech rights. And in this instance, we're kind of linking schools to government. And it doesn't really mean that anyone has to listen to what an individual is saying or host an individual while they're saying it. And they certainly have reactions which are portrayed here in the comic and are entitled to those reactions. To take it into a school format, the majority, or certainly the most quoted case pertaining to student free speech rights is Tinker versus Des Moines. And in 1965, 5 Des Moines, Iowa students, Mary Beth Tinker and her brothers, as well as some other folks, were protesting the Vietnam War, and in particular the deaths of American soldiers. And so they wore black armbands to school. And it took years, over 4 years, to get all the way through the Supreme Court, which eventually ruled that students didn't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Because these students, in a non-disruptive fashion, wore the black armbands to school, the school tried to take punitive measures against them for doing this. And what was important was that a student's right to political expression was allowed in public schools. And I want to clarify, students that go to private schools have far fewer rights than public schools. Certainly in public high schools, the rights are expanded if you are in a public library or in a community college or a public higher education college, for example, CUNY or University of Wisconsin. But in high schools, they're diminished. And we'll talk a little about that in a minute. Because of what they call the Tinker Standard, you'll see that, quote, students have a right to freedom of expression so long as it's not materially and substantially disrupting the operation of the school or violating the rights of others. And this includes, as courts have weighed, the right to, so long as it doesn't materially and substantially disrupt their own opportunities to learn. So student expression through demonstration, as in a walkout, is not constitutionally protected. So if students do a group walkout, that's considered civil disobedience, and they may be forced to pay the piper, academically speaking or administratively speaking. When it comes to the content of a demonstration and whether or not a student is allowed to say something or allowed to demonstrate or not allowed to demonstrate, it's really about the conduct and not so much the content. So you can have a rally over sharing information or having a demonstration or advocating on behalf of, say, a particular religion or a pro-political candidate or anti-political candidate, and the rules and policies have to be applied uniformly. So your school governance can't single out individuals, say, who wanted to vote for Frank Zappa over, many of the living candidates who may have been running for president. And so just to reiterate, the first part is that it's conduct, not content. If students are doing something unlawful or something that goes against the written policies of the school, that's how that they can be hung up on that. Also, free speech is for everybody, so it doesn't matter who wants to exercise free speech or how they're exercising free speech, whether they're printing documents or they have some sort of newsletter or they're writing a blog. Everybody has an opportunity to voice their speech, but the when, where, and how is how schools can weigh in on using what they call reasonable time, place, and manner restrictions. So, for example, students might be held accountable for writing or distributing newspapers on campus, on your high school campus or an elementary school campus. So the school admin has to make some sort of allowance and say that no out-of-school newspapers are to be distributed on campus, or all out-of-school newspapers may be distributed on campus, but only in certain locations. If students are hosting blogs or talking about school staff, it's one thing for them to print it on their private Facebook pages or in another private social media forum, so long as they're doing it after school time or out of school time. It's another thing for them to be doing it and hosting it on or sharing messages using school-owned emails or a school site or attempting to access these things on school time. Anything done on school time or using school resources means that the school has greater restrictions and governance over it as opposed to something that's being done out of school time. Again, the First Amendment rights aren't absolute for students or for staff. So students aren't permitted to publish hurtful lies, to say that a teacher or an administrator is a pedophile when they're not, or say something libelous. if or bullying, and we'll talk about bullying a little later on in the presentation, if it's a public figure that's being discussed, the laws are loosened for them because there's an anticipation that public figures will be subject to ridicule or to caricatures or to snarky articles like you might see in The Onion, for example. And here you'll see it's talking a little about school-sponsored activities. And when we refer to the Fraser and Hazelwood cases, they're two separate cases, and the links are below. Fraser was a high school senior who was making not obscene but innuendos that were heavily laden with sexual double entendres in a public speech, and the school took offense and wanted to clamp down on this and punish him with a suspension. One court ruled against the student, another court ruled in favor of him, and eventually the Supreme Court said no, if the school finds that the speech is inappropriate based on their criteria of causing a disruption, even though it's not obscene, they can punish him. And Hazelwood was about students printing articles in a school-sponsored newspaper, and certainly, and we've seen this over and over again across the United States, schools will attempt to gag and prevent students from talking about issues ranging from parental abuse, corporal punishment, contraception, a variety of topics. And these, nothing's really written in stone, and they tend to be fought topic by topic in different areas across the country. Which brings me to probably everybody's favorite topic, banning or challenging books. And we won't discuss it too heavily now. I'm assuming, as you're all professionals, you've talked about this. But when Kristen and I first met, we worked heavily in the West Bend libraries over here in Wisconsin with many, many concerned librarians, both from the town's public library and the high school library, due to a group's attempts to censor and remove books from the library. And here, organizations like the American Library Association are so important because they bestow a credibility and scientific and academic and a measurable process for determining whether or not something is age appropriate or topic appropriate. And these are vital resources for students, because when books are being challenged, students react to this. And this has been a really common form of demonstrations on campus. And here you'll see photos just from the Wisconsin area where students are getting together to host banned book talks, to celebrate banned books, to push back against challenges. And we annually have banned book week celebrations where folks are encouraged to come in costume, and it's a big mixed age event. Here you'll see, I'm not sure if you can see my cursor, Hermione from Harry Potter is sitting in the audience. And this was the only one that I could find of me not in costume. So I put that there. I'll frequently have glue on mustaches and go as Lord Byron or one of the monsters from Where the Wild Things Are. And it's a great way to have this, I don't want to use dissent because it's a strong word, but have students as well as faculty involved in talking about demonstrations and talking about dissent and talking about constitutional challenges in a way that fosters discourse and educated research and gets folks involved in exploring not only the topics but the library. And so this brings me to something that just occurred the other week, literally up the road from me at Bayview High School, whereby the girls' basketball team took a knee during the pledge and the anthem. And this caused controversy on campus. There was talks of repercussions for the students from administration. Many parents and folks in attendance voiced their support of the students. Other ones voiced their displeasure with the students. This was, the photo I have enclosed here was actually in the Daily News in New York City from a Sean King article that was talking about it. So there was national exposure, but this isn't really unique because this has been happening a lot since Kaepernick, who was the first really big public professional athlete to take a knee and not during the anthem and not stand. And so we believe that this is protected speech. We believe that this is something very much akin to the Tinker students who wore the armband. You're not really required to stand for the Pledge of Allegiance. The ACLU won that in the 1940s, back when we saluted the flag in the salute that is essentially identical to the Nazi one-armed salute, which changed obviously during World War II here in the United States. But it's still controversial, and it shows how, although one side or the other side may feel that these rights are written in stone, they're still very fluid, and communities have to come to terms with these things emotionally. And it's a really good opportunity for libraries to assist students as well as faculty and parents, because the debate was raging between the parents of the girls even on this team to come and find some discourse or to host an opportunity to be educated on the topics. Not protected speech would be what occurred in April in a more rural area of Wisconsin, where Beloit girls soccer team had traveled out to Elkhorn, and the parents as well as the students were shouting racial slurs at Black and Latina students. It's a multiracial team from Beloit, and chanting over and over again, "Donald Trump, build that wall." And the school administration has an obligation to stop that, and they did not stop that. And what was a beautiful thing here was the ally, who was the white coach, white male coach Denu, has this thing where he said, as a white male, I can't tell the girls I know what this is like, or that I know how you feel, because it's never happened to me. But I wanted them to know that we were there to support them, we were there to fight for them, and we're going to get through everything together. He stopped the game midway through, made sure that the girls were okay, addressed the opposing team, and then took the girls home where they could be safe. And I see this also as a very important thing for allies, both institutionally as libraries or librarians, halls of knowledge and places where hopefully we come to grow, and also just as members of a robust democracy where we need to speak up, whereby we may not be victims or be directly affected by the topic that may be affecting the students who are demonstrating. We may very well be the only adults who may be able to reach out to these students as allies and give them resources or opportunities to get through something emotionally, or to be able to articulate the points that they need to advocate on behalf of themselves. Another form of unprotected speech, which has caused a lot of demonstrations across the country, is our continued use of disparaging examples of non-white mascots. And many of us as Americans are inured to the misportrayal and mischaracterization of Native Americans as mascots. We have it in the Washington, D.C. NFL football team. And so I chose to use this mascot, which only got taken away a couple of years ago in Coachella Valley in California, where they're the Arabs, and they have this, horribly offensive Arab caricature as a puppet. The cheerleaders, although not in this photo, are frequently dressed as over-sexualized harem girls, and they do these dances. And for this community that was considered normal, but it's not normal. There was a town, I believe it was Toledo, Ohio, up until recently had a team referred to as the Chinks, and that was their mascot. And that's a very vile racist slur. And so knowing that this isn't, although it may be accepted in a certain area or school, but it isn't necessarily protected speech because it's abusive and it's bullying and it's degenerative, we need to do homework to find out what our local Board of Education or Department of Public Instruction has saying this, maybe help them create a stronger policy to protect the rights of the students who are being denigrated by this, who may be suffering because of the mischaracterization of their people, of the sexualization of the people, of the bigoted and not only disrespectful but dehumanizing portrayal of their people. This has given rise to many demonstrations and outpouring, and many of which is emotional, and we can't really put a qualifier on the emotional way that individuals may react to seeing such a derogatory mischaracterization of their mom or their dad or themselves. Another thing that has arisen a lot nationally and is certainly a current battleground in our state as well as many other states, is the rights of transgendered students, not only to be respected as who they are, but to even have the freedom to use a restroom. Bullying, harassment, discrimination, these are all very tangible and real experiences. And I sat in just yesterday in a transgender health rights meeting out in Madison, where it was revealed that Milwaukee Public School System, which is the largest public school system in our state, has now adopted a really robust and healthy policy recognizing and creating in black and white an opportunity to empower these students with rights to be accepted as who they are, establishing places for them to be able to change and what that looks like, and how folks can access restrooms. And what I found more and more is that school boards and school governance and how policies are written or what the policies are, although they may be distributed to public school students or college students upon arrival or the beginning of the school year, is not really a living document, in that parents in schools seldom revisit these things. And I've seen more and more that libraries are the places where they are displayed, or info panels, or things go up where parents can come to meet, or they'll reach out and work with PTAs so that the parents who may be getting into a parent-teacher association for all the right reasons can actually now go to get some training or some access and find out what the laws are within their municipality or within their state, or as written down in their school handbooks. And that's a very important thing to double check for, because how we feel about a topic or how something may be protected under a federal law may be very different from whatever vestiges we have or do not have written down in our school policies. And frequently, librarians and libraries are the bridge to reach out to students, as well as many teachers who may be able to find a way to work this into their curriculum. Which brings us to combating bias. Now, the illustration I have here is a mock subway ad. I do a variety of trainings, whether it's Know Your Rights during law enforcement encounters, or implicit bias trainings, or surveillance and technology trainings. And this was created to help discuss implicit bias. And the sign says, everybody deserves to be treated equally. It doesn't matter if you're black or yellow or brown or normal. And it's frequently greeted with, gasps of surprise, but this is really how people who are exhibiting bias tend to be wired. They don't realize that they're exhibiting bias, because this is something that we carry with us from our parents or our communities, our churches, our localities, and our religions. And so it's important to be able to provide information or resources for individuals to begin to explore this, or to read stories or access info that are told through different voices, so that we may be able to see ourselves through the lens of others. A concrete example of how this bias occurs in a school setting is just from the other year, whereby these three brothers here, two of whom are my Facebook friends, live in a small town in Sheboygan Falls, and this color photo appeared in a black and white newspaper. And the photographer, two of the brothers, had just scored 3 3-pointers in a game. And the photographer had them pose seriously, and then had them lighten up and make some photos. So they were, throwing the 3-pointer sign. The one brother's pointing at the photographers. And a security officer from a different school, not even in the state, saw this photo in the newspaper and called up a security officer from the Sheboygan Falls school and said, essentially, these black kids are throwing up gang signs. I'm sure that these are Crips or Bloods. I saw these same gang signs elsewhere. And the students, as a result of this and without due process, received game suspensions while the principal was looking into this. And this is horrible. And our executive director, made reference to then Attorney General Eric Holder talking about bias-based discipline. What they didn't address, and believe me, the Sheboygan Falls is probably the size of your library if you're in a mid-sized high school. There are no Bloods or Crips up there. And what wasn't addressed was that on the other page, there were white athletes from a baseball team making the same sign. And so ESPN and Fox Sports and other people picked up on this because it was so ridiculous, and they were showing then Speaker of the House John Boehner and other people all making the three-pointer sign and saying it must be Illuminati, it's not a Bloods or a Crips. And what it was that it was white security guards from very small rural communities were using a bias they have that they had gotten from whatever, from media, etc., to apply a judgment to these students. And luckily, the public outpouring and the fact that these students were able to get assistance through us and through other individuals in the community, as well as the media, they were able to get the suspension lifted, and it caused the community to take a long, hard look at themselves. This has been an invaluable resource for me working with libraries out here, in that discussing bias through many other voices, whether it's the absence of characters, as illustrated by Apu from The Simpsons in the lower right-hand corner, who, along with Gandhi, who is not fictional, are oftentimes the only Indian individuals that folks know of. Prior to, say, the Mindy Project and Master of None appearing on Hulu and Netflix, if you happen to be paying for those subscriptions. In the United States, less so Great Britain, we're sadly conspicuously silent in the portrayal of Indian folks, among many other ethnicities on the planet, in our literature. Arab in America is a wonderful book by Tawfiq El-Rassi, who speaks about bias and racism, how he's happy to be called a wetback and a spick when he moves to Los Angeles in the wake of 9/11 instead of in his true Palestinian self, because he was worried. Jean Luen Yang, obviously everybody knows, American-born Chinese, and he talks about his visions of race and how he feels other people see his Chinese cousin when he visits. And of course, the Boondocks is an Aaron Magruder, if you're lucky enough to have him speaking on a campus near you. It's wonderful portrayal of bias. And so frequently, bias is not only depicted in racist mascots, and many of us have, many places still have native mascots, but also how folks aren't depicted, and how people are forced to creating a new their own definition of a religion or a race or a sexual identity based on what they don't see, and therefore just on sparse clues that are randomly garnered. All of these manifest themselves in instances of bullying on campuses across the nation. Just recently, this year, we created an online resource for bullying, and it's not so much a kumbaya, how to live warmly with everybody and sing songs workshop, as a toolbox or a triage guide in how to contend with bullying and how to take a look at what our policies in our schools or in our states or communities say. Now, the resource I'm linking to here is very state specific, but there are hopefully ideas for how folks living in more rural or urban areas can access resources. Sometimes the parents don't know how to work with their child. Their child may be the first outward transgendered relative or lesbian or gay relative or bisexual, and they don't know how to get resources for them or where they can learn more. They may be the only person of color in an ever-diversifying community, and they don't know where to get help or what laws pertain to them or what they can read to find support. And this is a tremendous way in which libraries, as well as schools and local community groups, can work together as a team. The link is on the next page, and I will definitely provide that, Robert. Some resources for combating bias are all listed here, including the bully resource, and I'm not sure if you can see my mouse underscoring that, but Marvel Comics is doing a tremendous job right now in addressing cultural and religious otherness, or not the predominating Christian religion in some things. Like Marvel Girl, for example, is a young Muslim teen from New Jersey. And they have many other fantastic ways of exploring this. And just briefly, if you don't know these resources, tolerance.org has great resources for high school, elementary school, and middle school students that are taking a look at combating bias. Southern Poverty Law Center and their free magazine provides a wealth of resources, including The Year in Hate, which should be coming out in January and does a state-by-state of hate groups. The Comic Book Legal Defense Fund, and I contribute to all of these groups, certainly because I'm a comic book geek. And we have a lot of librarians in our comic book meetup group too. So come on out when you visit. It has a lot of great resources for addressing many of these issues, including demonstrations and First Amendment rights, and ACLU and our own local ACLU. So now let's take a little peek at the school to prison pipeline. More and more, there is a greater police presence in school. Police are being used by school admin to weigh in on areas that should really just involve parents or school administrators, and this is not a help. It certainly escalates the situation and puts police too in an unfair relationship whereby they don't have the training to deal with students who are likely to mouth off or say things. They're put in an environment where frankly, they don't have the skill sets or the tools to deal with this, and so they're going to react in the ways that they were trained to, which is frequently with oh, great to meet you online, Betsy. To give, we did a fundraiser for you the other month, to give harsh reactions to students. So we're going to talk about how this plays out on your campuses. And the Bieber is a nod to Kristen when at the ALA conference in the state, everything was Bieber up in here. And this is from my friends who are going to Xavier School for Gifted Youngsters. Students have, the schools have less of a threshold for probable cause or reasonable suspicion. They can essentially search students' lockers, their backpacks. If they park a car on a campus parking lot, they are permitted to go in there, and they don't need warrants for these things. And although it may vary from state to state, I know it's, for example, it's not true in California and Massachusetts, and I suspect in public schools in New York. In Wisconsin and many other states, schools are allowed to go into a student's smartphone. And so I encourage students and for parents to talk with their students to lock their cell phones and say respectfully, teacher or school admin, I don't consent to search of my phone. Please call my mom or dad. And I say this for a variety of reasons. One, because there's a lot of private information on phones now, not the least of which is financial, iTunes account, Google Play's account, but personal communications between parents and children. Dad has been drinking. It's not safe to come home. Go sleep at your aunt's house. And that's really for the parents to work out with their children and not necessarily to broadcast this everywhere. School officials, just like police, need to be able to articulate why they're doing a search. They can't base it on a hunch or a baseless rumor or curiosity. And schools need to lay out these policies in writing ahead of time. And we need to examine our own policies. Are we only searching the backpacks of students coming into the library because they're black or brown? Are we doing this arbitrarily? Are we doing this uniformly? Police may be invited to search students on premises at the invitation of the school admin or the school security guards. And many of your school security guards may very well be off-duty deputies and police officers. Certainly, Racine in Wisconsin seems to almost exclusively use off-duty sheriffs and police. And this can be horrible. There was an example from about 10 years ago whereby the school security officer noticed on another student's Facebook page that they were looking to get weed. And they said, I'm looking to get high after school. Who can help me? And another student responded, I got you. Let's meet at X, Y, and Z after school. Now, at no time did the security officer go to the school administrator, say, Principal so-and-so, you have students, who I suspect have a drug problem or are looking to get high, or, social worker or guidance counselor, this thing is going to occur, and I really think you should speak to Timmy and Johnny before they get in trouble. Or even reach out to the student. You're being pretty foolish posting this publicly. You can get in trouble. What they did is they waited until they punched out as a school security officer. They punched in as a police officer. They put on their uniform, and they waited on the corner for the students to show up, and then they arrested them after they made their drug transaction. And now the student who is buying marijuana is looking at facing 3 years for felony charges. That has nothing to do with youth development philosophies. It has everything to do with the gotcha mentality of punishing young people for committing a crime. This happens on our campuses all the time, and parents in the community are unaware, and I believe it's the obligation of those that understand these laws or opportunities or the way things can happen to educate families about this. In regards to searches or boundaries, searches have to be really specific. I mean, there are many examples that wound up becoming Supreme Court cases, like 13-year-old girls in Arizona being strip searched for possessing, of all things, a Motrin as potent as 2 Motrin. It took 7 years. She was in middle school and she had already graduated from college by the time the Supreme Court heard this. So these types of battles are best meted out by creating positive policy and educating people on the rules instead of fighting them out in the courts, which will never have immediate justice, but moreover probably be won long after the damage to the people involved have come and gone. And then you'll see what I said earlier. Just so you know, for the most part, video and audio surveillance, prevalent pretty much everywhere in our society, is only increasing, not only in our own personal possession of phones, but also in schools. So here you'll see some examples of CCTV in schools. They have the right to install closed-circuit cameras in your libraries, and it may be done under the pretense of security, but what does this mean when they're pointed at the screens of your computers, or that individuals perhaps can blow up the resolution? And certainly higher definition cameras are getting more and more affordable on these screens. But for the most part, unless it's in a bathroom or a locker room, they can't have the cameras there. And now I'm going to jump to some more explicit dangers of and benefits of social media and the prevalence of having cell phones. On the right-hand side, you'll see images of police officers who have intentionally obscured their names and badge numbers with black electrician's tape. This happens more and more. It happened a few months ago on UW-Milwaukee's campus. It happens on college campuses a lot more, and it happens in the streets. People think it can't happen here, and I have probably a collection of about 40 different officers who have obscured their badges just in my home city here. In the lower left-hand corner, you'll see a young man who is both a scholar and an athlete and a good student who, responding to, there was bullying in his school. And the principal wanted to stop the bullying because there's an incident of a boy being beaten and the video is being shared on social media. The principal didn't know how to do this, so he reached out to his local law enforcement to assist. At the invitation of the school, the police came into all the different classrooms and said, "We're looking into the distribution of this bullying video. We'd like everybody to pass forward your phones, please." This young man who was not a participant in this bullying said, "Well, I don't do this. I'm happy to pass forward my phone." But because child pornography laws pre-exist this data, and because sex offense laws and other things are also in existence, because he had a nude photo of himself and a separate nude photo that his girlfriend sent him of herself, he was in possession of child pornography. So in most states, and because he's also in South Carolina, this is treated as an adult offense. He's looking at spending 20 or 30 years felony incarceration as an adult for a possession of a nude photo of himself on his phone. In most states, if I were 16 and I took a photo of myself, I then sent that photo to my boo thang, and then she took one of herself and sent it back. I created child pornography, distributed child pornography. She received and then stored child pornography. She created child pornography. She distributed child pornography. I received and then I stored child pornography. It's like a basket of felonies. And for all the best intentions, this young man waived his right, and a very important right, which is, respectfully, I don't consent to search for my personal property. And that's why all of us need to do our homework on security and encryption, and know that we have a right to say no. We should certainly lock our phones and demand that our parent or our guardian or a trusted school official is there to help us waive these things, and know that we should say nothing at that point and sign nothing. An example of Yik Yak, and I'm not sure how many of you are familiar with this, it's not really allowed on high school and middle school campuses, and since it's a geosynchronous application, they're able to block it. But it is prevalent on a lot of college campuses. And this guy here, during the university demonstrations at the University of Missouri, said that he was going to stand his ground and shoot every black person he sees. And school officials reached out to Yik Yak, and then working with the police, Yik Yak, and this uses an automatic anonymizer so that it's not that you make up your own name. Every time you link into Yik Yak, it generates an anonymous name for you. But Yik Yak on the back end was able to see who this was, and this creep was arrested for threatening to shoot black folks during the Mizzou demonstrations of November 2015. So that's not an example of protected free speech. That is a threat. Exigent circumstances, too, whereby they feel communications maybe, say, like the San Bernardino shooting, if they've been texting somebody and they were concerned that you were texting them and you might have information that would allow them to save lives, they don't need a warrant. They're able to take your laptop or phone or kick down your door. Here's a horrible example where this sheriff's deputy, Ben Fields, put the girl in the stranglehold and threw her across the room. And I'm showing this not so much for the brutal and wrongful actions that he exhibited against this young woman, but because the school's response and the police's response was to try to punish the girl that videotaped this encounter. That was their very next thing. He turned around and ticketed and arrested the girl that videotaped this. And the school was happy to try to oblige until the public outcry. Parents in that community wanted to know what to do and where to go. And certainly lawyers and civil rights groups reach out, but this is a vital opportunity for libraries to also discuss rights, and there were demonstrations and protests there too, and to share these things. All of your ACLU affiliates, as well as the Electronic Frontier Foundation, will be happy to share what the rights of students are, and I'm happy to share. I create these little triptych cards, trifold cards that are wallet size, which have Wisconsin-specific rights, but they may be applicable in your areas as well. Ideally, each of your schools and libraries will have phone and social media policies in place. They're really important. Schools aren't allowed to post from accounts, and they've done that. There are examples in most states where a principal or a teacher has violated entrapment laws, whereby they've texted on behalf of students with confiscated phones, inviting folks to get high or asking who's got whatever contraband they're saying. Certainly, if you don't want anything shared, don't post it. Don't take that photo if you don't want it shared, because it can always happen. And it's important not to give consent to searches. Matt Bohr's got great political cartoons on a variety of these topics, and here I've included one for you. I'm assuming you all know about the confidentiality of library records better than myself, but these have a more chilling effect now. There's a greater fear, especially among Black and brown communities, immigrant communities, and Muslim communities, that their records will be asked for, what they're searching on computers will be asked for, that somehow there will be a diminishment of the walls of communication between the federal government and your local library or your school. These are all very important. Remember, law enforcement needs a court order signed by a judge to get certain records, or it needs to be a custodial parent or guardian who is asking to see these things. And ALA and certainly the Office for Intellectual Freedom and Kristen have all of these resources for you. In addition, each of your states has statutes that speak to this as well, what you need to maintain, what you don't need to maintain, and to whom and when you sign these things over. The chilling part is that the Patriot Act has, under Section 215, has really granted law enforcement an ability to attain, without an ordinary subpoena or search warrant, court orders to access business records or any tangible thing, which then now pertains to booksellers and libraries and credit card companies. And also they have an opportunity to use a gag order, which would prevent you from discussing these things. So it might be that your head librarian will be demanding these records and won't even tell you what they're for. And this has an extremely scary and chilling effect, as Mrs. McGonigal can tell you. What can be done? Well, make sure you follow the letter of the law. make sure wherever you can, you speak to an attorney, you speak to a school attorney, you speak to whatever attorney your librarians can get, and you review the laws and enforcements that are listed there on the ALA. Make sure that everybody is familiar with these types of things. Not sure what that pop-up is there on the side. Thank you. Policy development. Let me see if I missed anything here. Nope, we're good. So policy development, I can't underscore this enough. If we don't have good policies in place, and they're constantly needing to be rewritten. So I use the example of transgender young people. New policies need to be rewritten, and this is a really good opportunity for libraries and librarians to reach out to their school boards and their PTAs and school staff to see who else has quality policies in place, or what other resources might be in your state, you know, a GSAFE, a PFLAG, whatever GSA councils might be there that certainly more rural or less open communities may not be accessing, to make sure that these resources are available for others. I see that there's chat on the side, and I'll jump to it in a second if Robert or Kristen aren't already addressing it. Policies also need to be applied without discrimination. If you have an unlawful policy, or if your attorney or the city attorney isn't good enough, it can open you up for lawsuits. Just ask the ACLU. If you witness rights violations, you really need to document that. People confide in librarians a lot, and certainly you all are viewed as resident scholars, whether you like it or not. And so it's really important to document these things the same way you would document things closely and clearly after a burglary or a car accident. And you can get advocates, and young people and parents need to know that they can get advocates. If they've been demonstrating and the school feels like there's a violation, it might behoove you to link them up with local ACLU, or let them know that they have the right to a public defender, that no students should speak to anybody without their parent present, that they don't have to consent to a search, and they should say that verbally and not act on that physically. Because remember, in your schools, they can correct. In the schools, they may be able to search. They certainly can search the backpacks in the schools and the lockers, although they need to have some sort of articulated reason why. There are a lot of important ways to support what we're doing now. Education, providing resources is vital. Nobody, I tell you over and over again, I just trained 70 folks in Madison on this yesterday, and the several hundred I worked with over the immigration reform and the Muslim registry. Nobody knows where to get good information, and people will cling to rumors as much as they will good information. Nobody knows where to get resources, and this is vital. We believe that libraries should promote a diverse society that better understands values and protects civil liberties and civil rights. So I'm going to take a look in the chat now and get to some of your questions here. I see Barb Bratton is discussing the case of the individual on Yik Yak. Yes, arresting for threats and prior restraint. That's a great question. You know, and this changes from location to location. So for the most part, in most of your states, schools can use, and this is for, I'm talking K through 12, they can use students' previous actions as reasonable suspicion or probable cause. So because a student has done certain things in the past, it's really a gray area, and they can base it on that to sadly continue to punish or to push on the student. So so that's one example. The individual who actually made the threat, that's a criminal threat subject to arrest. And so for an adult, that's very different. When we're talking about dangerous or potentially dangerous or viewed as dangerous or controversial free speech. So a couple of days ago, we had Milo Yiannopoulos, and I'm not sure if you're familiar with him. I find this individual rather abhorrent. He's got something called the Dangerous Faggot Tour, and that's what it's called. It's stenciled on his bus, and he has a right to say these things, and he just spoke at UWM's campus. And there was a huge cry of individuals who felt threatened. And the campus, we believe, has an obligation to host speech, even offensive speech like this, but to make sure that their students and student body are safe. And so they set up safe areas. They provided alternative opportunities. The ACLU sent legal observers to monitor the interactions between law enforcement and the schools with both the demonstrators and counter demonstrators. And you know, it gets a little ugly. There are masked agitators who work for Milo, and also Milo himself, who go out there. He did something rather abhorrent whereby he took the photo of a transgendered college student that was going to that campus and put her up on the projector to mock this individual. And so there's a lot of different issues in there. Let's see. Robert writes, I always like to remind people that the so-called Patriot Act is actually called Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act of 2001. USA Patriot. Oh, Patriot. Yeah, that's horrible. Yeah, that's an appalling acronym. And that's a good point, too. And remember, too, how, again, with rumor and efforts to change policy, individuals will attempt to make demonstrations like the Black Lives Matter, which has an ever-increasing national manifestation on K through 12 campuses and college campuses. They try to label that a terrorist organization. Frequently, individuals will attempt to label something that goes against a majority viewpoint or is offensive to their viewpoint. They bandy the word terrorist out a lot, and it's up to us to underscore what is the law and what are healthy and safe policies on our campus to make sure that individuals don't get thrust into these. Every high school in Napa had a school walkout after the election. I love that. I was with them in solidarity, Kate McMillan. You're still rural and have a conservative white population in our district that is 54% Latino. We are partnering with our county library to provide resources for both students and staff. So it's a work in progress. It is, although many of these things are rules, such as, you know, exercising your right to say, I don't consent to search of my personal property, I don't want to talk to you without my attorney present. These are all works in progress. More and more, and because of hostile court rulings, individuals have to assert repeatedly that they don't want to talk to law enforcement without their parent or a trusted school official present. Or not sign anything. They shouldn't sign things for school admin necessarily. They should make sure that their parent is there. Knowing what the rules are and then having law enforcement or school respect those rules, knowing that there are nuanced differences when the principal has invited police into the school to speak to students or perhaps to arrest students for having a sit-in or a walkout. These are all like really nuanced areas where you'll need to reach out to legal counsel to guide individuals. Many places, if you take a look historically, when the Occupy movements were occurring and students were walking out there too, even police in some larger municipalities and cities attempted to arrest a lot of these folks, and that was a PR snafu that blew up in their face. Can you ticket individuals for taking the streets unlawfully without a permit and blocking traffic? I'm sure you can do that. Did that work out for them? No, it didn't. And many other municipalities chose not to do that, and then to actually have law enforcement guide traffic so that it didn't bump into the demonstrators. Many schools have walkouts, and in some instances they attempted to ticket or punish students that do that. Now, this is an interesting area. Are they only doing that to demonstrators who are protesting, say, a Trump election in a predominantly conservative area, but didn't do that for a group walkout for some sort of sporting event? Or are they only doing that for the Black Lives Matter, but aren't doing that for some sort of prayer group in a local park area? It's really important to take a look at the laws and policies and then how these things are being applied. Leah has a question about why the ACLU is taking University of California, San Diego, I believe, to court for censoring the Koala in light of Fraser and Hazelwood decisions. I'm not sure this is in your wheelhouse. The Koala is a humor magazine that published racist and inflammatory articles following a fraternity being disciplined for racist Compton cookout party, and subsequently students placed a KKK hood on a statue outside the library and hung a noose. Oh, that's absolutely horrible. I don't really know about this. That's your local affiliate, and I'm not sure. I'm happy to look it up and reach out to my colleagues there. I apologize for not knowing about this. We're big. We have 53 affiliates, and I can look into it. Certainly, we've defended folks like Larry Flynt and Hustler, who also has kind of abhorrent satire as well, and frequently racist, because we come down hard on government infringing with free speech generally. So we believe that free speech, even if it's offensive and abhorrent, is best countered with more free speech, and it's not really up to the government to say who has the right to the soapbox, because it's almost always, and historically speaking, it has always been the women, the LGBT community members, and ethnic and religious minorities who have suffered on the short end of the billy club there. Patty and Shari are coming up with questions as well. I'm going to pause for a dramatic sip of water. I hope that my thick Queens Brooklyn accent isn't too much for all of you listening when you anticipated that I would have a don't you know Midwest accent. I really have found more and more in the past month or so that communities, both heteronormative white Christian communities as well as communities of color, are having a huge cornucopia of questions. Last night, the training we did on how to be a legal observer and monitor law enforcement interactions between whatever type of law enforcement and demonstrators. We were originally going to do that at UWM, and the room we had was too small, so we did it at the Hawthorne Public Library, and it was a standing room only event with about 75 folks who braved 0-degree weather. And I'm finding that libraries are now becoming a very active hub for distributing Know Your Rights cards and for sharing information, mostly because individuals have no idea where to go to get this, and rumors are as broadly disseminated as fact, and a lot of this is speculation until January 20th. Can employees in right-to-work states implement workouts? They can, and this is also, you're going to want to contact an employment law attorney about this, because this changes from state to state. Walkouts is another form of civil disobedience, and civil disobedience is a broad spectrum too. I mean, you can handcuff yourself to a door, you can try to do one of those system overloads, where an administrative overload where everybody tries to pay some sort of unwanted, I'm sorry, trucks are going by my window, unwanted fees and pennies. So they can implement walkouts, and I don't believe that that's subject to arrest, but it might be subject to some sort of punitive measure from their employer, so they could be fired behind that. But I do not believe that that's unlawful, no. But certainly that gets kind of nuanced, and when individuals who are demonstrating, like, you want to take a look at your local ordinances. Demonstrations are a whole other can of worms. You can't generally have stationary demonstrations. They have to be mobile demonstrations so that you don't pick up a loitering infraction or an obstruction infraction. You can't block the ingress or egress to buildings, so you can't really block the entrance to schools or to stores, for example, even to hand out pamphlets, because you can receive a ticket behind that. You can't incite people to violence. That's subject to criminal arrest. Threatening and harassment are also actions that are subject to criminal arrest. Having a walkout is an interesting thing if you're a student, because if your law enforcement is particularly hostile, you want to see what your truancy laws are. And so sometimes demonstrators and students might want to meet with an attorney prior to these things, or or get some sort of advice before they do this, because you may be in a municipality where the local sheriff's department or police department are very hostile to the content and not necessarily the action, and so they're going to attempt to ticket individuals, and they have, and they do all over. You know, things like passenger on a freeway. They suddenly decide that they're going to ticket folks for this. They may not ticket individuals for honking their horns in support. So students honking horns is a big sign of demonstration, and so you may have law infractions. You may have a zone where you can't honk horns because it's near a hospital. They may allow them to honk horns during sporting events, but then ticket them during some sort of political event. And then you have an opportunity for a lawyer to defend them because there's a bias in the implementation of the law. So frequently it comes down to whether or not there's a bias. Oh, that beautiful mural is actually on the wall in my office. So if you're ever in Wisconsin, I love librarians. I have librarians in my family. Many of our board members are librarians. We have a lot of card-carrying ACLU librarian stock, and so you always have a warm place to visit when you come to Wisconsin. You can check out how I've decked out my office in steampunk and sit in my refurbed carnival chairs.
Well, except that actually right now you don't have a literally warm office.
You know what? It's a metaphorically warm office. I'll give you a hug because I'm Spanish.
There you go. Listen, I hate having to cut off Emilio because I think he is not only great to listen to, but he's full of information. But don't hesitate to contact him and email him if you have further questions. There is a slide here at the end that has our survey on it. This will ask you for some quick feedback on our session today. And I just really want to say thank you, Emilio, for coming today, for sharing all this great information and encouraging so many people to support young activists. I mean, today more than ever, we need kids to stand up for their freedoms, for their rights, and they need librarians and educators to support them. So thank you very much for coming, and I look forward to seeing you all in future webinars.
Thank you, Kristen. Thank you, everybody, for attending.